tell you about the chat. We all now know the recording's in progress, so thank you for that. I'm going to invite you to use the chat button in a few minutes, and it has taken me a while to learn the chat button. So when you type in the chat, you then have to go to your keyboard and hit the enter key or the return key. I keep looking in chat for something that says send, and there is no such thing. So if you will, in a few minutes, I'll ask you a couple questions, and you can use the chat button. And as I said, if you will type in your message and then hit the return key. I sent out some slides yesterday, or Jackie Welsh on my behalf sent out some slides yesterday. We're going to use some, but not all of them today, so keep them for next week as well, please. And that may be all the announcements, other than to tell you that today, some of the material that I'm going to talk about, you may have heard before. If you've taken a course from Jill Adams or a course from R.J. Robertson or from me in the past, you've heard some of this material before. I would like to tell you that I'm building on what Jill and R.J. has done, but actually I'm just plain stealing what R.J. and Jill have done. So I give them credit. Mistakes, of course, are always mine. The reason I don't mind repeating is some of this is a bit outside of the realm of most of you. And if you're like me, when I go to the doctor and they're talking about things, I have to hear it 2 or 3 times before it makes sense to me. So I don't mind repeating for that reason. Also, because we vote on some of these things, and I think it's good that we understand it. So please bear with me if it's repetitious. The other thing I want to say is I'm going to skip around a bit today. It may not always feel as logical as I'd hoped it might, but I'm hoping that it all ties together. A question came up while we were getting ready. Somebody's telling me they did not get the slides. You're going to see them here today, so don't worry about it. You're going to see them, and if I remember, and I've just written myself a note, if I remember 2 hours from now, I will send you the slides. The other thing I wanted to mention was a question came up before we started the program that has nothing to do with civil trials, but is a question out of the news, and let's talk about it. So yesterday, R. Kelly was found guilty in federal court in New York. 2 things you might think about there. First of all, why federal court? Because sex crimes are basically the kinds of things you'd expect to see in state court. But he crossed state lines to get young women. And when you cross state lines, you violate a federal law, and therefore there was a basis for federal court. I will tell you that if you're plotting a crime and you want to be tried in state court and not federal court, do not use the internet, do not use the phone, do not use the mail. Find an empty garage, meet there at midnight and do your plotting there. Make sure nobody's wearing a wire, and then you will be protected, I hope, from from federal court. But of course, the better thing is don't plot crimes and don't commit crimes. But the other question that came up with regard to Kelly's trial is he was found guilty yesterday. He's not going to be sentenced till May. Why the length of time? And the answer is, whether it's the federal system or the state system, there needs to be a period of time for a pre-sentence report to be prepared. And in the state system, that's done by the probation office, the county probation office, and there's a similar office in the federal system. So it takes a little while to do that. They research the person's life history, basically, and put together a pretty thorough report for the judge to consider. Now, Professor Robertson's wife is a federal prosecutor, so he added to my discussion and pointed out that even though there are few federal trials, there are tons of people who plead guilty every day. And each of those people is entitled to a pre-sentence report. So it takes a while for the probation officers to prepare all these. Plus, we're all working under COVID restrictions, probably fewer people working from home, all those sorts of things. It takes a while. So that's the news brief of the day. So for today, I want to pick up with two questions that were left from last time, and we should have discussed them last time, but let's do it now. One question was, do I think that the jury can figure out the facts in these cases? And I'm going to turn that over to you in just a second. And the question I raised last time, and I'm going to ask you all to think about, if you've ever been on a jury, how did you respond when you saw the attorneys objecting? How did you respond when you saw the attorneys huddled at the bench with the judge and you're watching the backsides of all these people? So the first question, and this could just be a yes or no, and you can use the reactions button. Remember, the green check is yes, and the red X is no. So would you use the reaction button and tell me yes or no? Have you ever been on a jury? Yes, if you've been on a jury, no, if you've not. Okay, I would think we only have a few people who've been on a jury. Interesting. Okay, so among those of you who've been on a jury, you can erase your reaction button. Those of you who have not been, you don't get to participate for the next minute or two, you get to listen. So if you have been on a jury, would you go to the chat button? And on the chat button, would you tell me, the first question I want you to think of, answer is, were you able to figure out what was going on? Did you feel confident by the time you issued your verdict that you understood what had happened? You understood the basic facts. And if you were on a jury, would you just go to the chat and tell me that? I will use the pause here to remind you that we do have closed captioning. So if you are interested in doing that, there's something at the top of your page, your screen that allows you to do closed captioning. So
At the bottom of the screen.
Bottom of the screen, top of my screen. So it may vary. So yes, I think I understood. Perhaps I was erroneous, but I think I understood. Several people, others are saying yes, yes, yes. Somebody says it's a long time ago, may not remember. I can't imagine that any of us would ever forget those sorts of things. So yeah, it looks like people get the sense that they did understand. Now, a question has been raised I think it was last time. What about highly technical matters? And I'm going to return to that on the last week and talk about, if you had a highly technical case, would you want a jury to hear it? We'll look at that the last week. Okay, my second question to those of you who have been on a jury, how did you react when you saw the attorneys and the judge huddled at the bench and you're not listening and you're having to wait until the huddle is over? Or how did you react when you heard a lot of objections during the trial, if there were a lot of objections? So if those of you who have been on a jury want to weigh in on that question, please. Okay, somebody says the objections didn't bother me. I didn't like how mean the judge was to the attorneys. Perhaps they deserved it, but it bothered me. That's very interesting. Most judges I know, even when they're upset with the attorneys, try to keep that in chambers and not let that be seen in front of the jury. But not every judge is great. And next week, by the way, we're going to talk a little bit about how one becomes a judge and how they're trained and evaluated and that sort of thing. So maybe that will resurface. Someone else says, it seemed as if things could have gone much quicker. And I assume that means if they hadn't been so many objections. And someone else said, it didn't bother me. I understood why they had to make them. Well, let me tell you that in Illinois, there are 60 separate rules of evidence. One of those, which is the hearsay objection rule, has exceptions. There are 25 exceptions to the hearsay rule. So I'm going to guess that when we look at all the subparts, there's probably 100 rules about hearsay, about evidence. And if I don't make an evidence objection at the time it comes up, I lose it on appeal. So if I want to appeal and I want to say that the judge made a mistake in a ruling, I have to give the judge the chance to make that ruling. I have to object so that the judge can rule that evidence in or out. If I really think it would harm the jury to hear it, or it will harm the jury in the sense that it would prejudice the jury about something that should not be relevant to the case, again, I have to make that objection. There's a story told about one of the best trial lawyers in Illinois. And a case was on appeal. And the people working on the appeal came to him and said, sir, we found this one issue here that would be really good for appeal, but you did not object. And he said, how many days or weeks has it taken you to review that transcript and find that? Well, we've been working on this for 3 weeks, they said. He said, if I'd had 3 weeks, I would have made that objection. So the point is that in the midst of trial, you've got a split second often to make these objections. And if you don't, you've waived it. So that's why you see them. However, if you have good attorneys and a good judge, a lot of this gets worked out in advance, and the attorneys know what's going on, and they don't have to constantly interrupt. They know that they can trust each other. Let me give you one other story. Many years ago, in my young days and as an attorney, I used to appear in hearings where we were trying to uphold a personnel decision. So the state of Illinois decided to fire somebody or decided to suspend somebody for more than 30 days. They were entitled to a hearing. Now, this was not before a judge, but it was before a hearing officer, and it operated a lot like a trial. Well, on this particular case, opposing me was a young attorney, younger than I was in the sense of new to the profession. And while I was putting on my case, she was making every objection you could imagine. Typically in these cases, I know that the hearing officer is going to let everything in, and the hearing officer is going to sort it out because he hears these cases every week. He has a pretty good idea what's relevant and what's not relevant. So it was a little unusual to hear this attorney making so many objections. So when it was her turn to defend the employee, she was trying to establish a date where certain things happened. And she was correct, the date was correct, but she wasn't accurate in how she was establishing that date. And I objected. Now, let me tell you, that is the most stupid objection anybody could make. It was relevant, it was proper, but there's a word I'm not going to use here, but it refers to cow manure in terms of how picayune and stupid this objection was. Of course, it was overruled. We proceeded with the hearing. From that day on, anytime she and I were together at a hearing, she did not object unless it was necessary. We never talked about it. I never had a private discussion about, if you keep doing that up, I'm going to do this to you. We just never talked about it. But I think she got the message that stupid objections were just a problem, and we weren't going to have them if we wanted to proceed. So yes, sometimes you have to make them, and sometimes you're making them to aggravate people, and sometimes you're a new attorney trying to learn all the rules, any number of reasons. I just appreciate the fact that jurors bear with us. All right. Well, that brings us up to date with what was left from last week. What I want to do today, the first thing I want to do today is talk about our common law system, because if you remember on day one, we had this car accident and we said, I've been injured. You've been injured. You're the plaintiff. You're the person that got hurt. You want to file a lawsuit. And we pretended that you were rather naive and knew nothing about these sorts of things. And you were trying to figure out where could you go? Is there even such a thing as a lawsuit here? And we decided that yes, under the common law, there was. And I briefly talked about the fact that we are a common law nation. Well, I want to talk about some legal systems because the common law system is not the only one. So I'm going to share my slide and show you a slide about the various legal systems. So I don't pretend that this is exhaustive, but I think these are most of the legal systems in use in the world today. And I'm going to talk mostly today for a while about the common law system. It is used probably by a third of the world's population. It comes from England as that's where we got it from. So about every country that was a British colony probably uses the common law system. The civil law system, which I'll talk a little bit about in just a couple minutes, is used by continental Europe and many of the places where continental Europe, France and Spain and Italy in particular had colonies or had a presence. Islamic law is based on the Quran. Don't think about Afghanistan. Think about a country like Jordan. Jordan's a fairly modern country as those developing countries is, and it has both a secular and a religious legal system. So for a lot of matters, they use a secular system, but for matters related to family, estate, who's going to inherit property, they probably go to a religious system based on the Quran. Talmudic law based on the Torah, Jewish law, even in the United States, among very strict, observant Jewish couples, if they are getting a divorce, they use the rabbinical courts. And every once in a while, you will hear something on the news about someone trying to get a divorce through the rabbinical courts and the problems associated with that. Again, to a large extent, in Israel and certain isolated Jewish communities throughout the world, this tends to be primarily family issues. Totalitarian law, of course, is whoever is in charge. So I could have said communist law for those places that are still communist, but it's basically a country where the government is telling the courts what to do. Tribal or native law. Some of you may read books by Hellerman. I think it's Tony Hellerman. He is a Navajo mystery writer. He writes about crimes and mysteries. He frequently gives you some insight into the differences between how the American national legal system might handle something and how a tribe might. And here's one example that I vaguely remember from one of the novels I read ages ago. So there's a hit and run accident and someone is injured or even killed. And the police officer, who's tribal, pretty well thinks he knows who did it. Now, if he arrests this person and puts this person in jail, then two families suffer. The family of the driver, because now the driver is in jail and can't provide for his family. And the family where the person was injured or killed, of course, is still suffering. Or he could follow a native custom, which is to require this person to compensate the family that was injured or harmed or killed and continue to support his own family. He often blends some of that in his writing. So if you're interested in that sort of literature, you might check those out to get some insight into native law. And then there's canon or church law, which governed part of Europe for many years, many decades, centuries, I suppose, is still in effect today, certainly in the Catholic Church, to a large extent, the Anglican Church, but other churches, Methodists, Presbyterians, among others, have some sort of code-based system of law that's used within the church. Now, I'm not going to talk about anything other than common law and civil law for the next few minutes, but I want you to think about something. Those of you who took the course that I talked about Robert Jackson, and I talked about Robert Jackson being a prosecutor at the Nuremberg trial in Europe after World War II, where German, some of the high command were tried. And I mentioned that the trial was brought about by the victors. The victors were France, which is a civil law country, England, a common law country, the US, a common law country, and Russia, a totalitarian, or at that point, communist country. And I mentioned how difficult it was to devise a legal system when you had the victors from 3 different legal systems and they had to agree upon one. I think that is one of the many absolute miracles of how that Nuremberg trial came about. I just found something that I wish I had known a long time ago. Sorry about this. Let me get back to where I need to be. I should learn not to press buttons if I'm not sure which button I'm pressing, but so I apologize. I just found out that the US government puts together discussions of the various legal systems. So there is something called an introduction to a Department of Justice National Security Division Office of Justice that has put together an article, a little booklet, I guess you would call it, for victims of overseas terrorism. So the purpose of this was to tell Americans who were a victim of terrorism abroad how they might or might not sue the nation or the group who caused the terrorism. So the United States Department of Justice put together these little discussions about the legal system of various countries. So if you want to know more about the civil legal system, you can go to this website and check it out. If I had known such an entity existed, I might have applied for this job because it's the sort of thing I would have liked to have done, and to have the federal government pay me to do it, that would have been great. I also happened upon the US Embassy in Argentina. This is what happens when you just play around with Google. So the US Embassy in Argentina, and I assume other countries as well, puts together a legal system of the United States for the benefit of citizens in Argentina or wherever. Again, that would have been something I would have liked to have done. So if you have nothing to do, check out these various descriptions of legal systems. But let's continue with the American system. So where did we get this? Well, let me pause before I continue and talk a little bit about the civil law system. So let me stop for just a second. So I'm going to tell you that 49.5 states in the United States use the common law system. I'm going to let you think for a minute or two about the civil law system and see if you can figure out and guess which is the half state that does not use a common law system. The civil law system, as I said, I want to just take a couple minutes to tell you about. Originally Rome, and then throughout Europe including more recently the Napoleonic, there we go, Napoleonic Code. It differs in that there's probably very few jury trials. Judges have a much more active role from the beginning. They do a lot more investigating. In some cases, there are two judges, the investigating judge and the sitting or trial judge. There are lawyers and they help the judges, but the judge is in charge of conducting the investigation. So the issue of could a jury figure it out is not going to be an issue. It's the judge who does the figuring out and presenting the evidence in the end to the trial judge. The civil law system is not judge-made, as we call our system. It is based upon codes, CODE codes, that put together basic principles that govern a particular area of law, whether it's business or family or estates, wills and trusts, that sort of thing. So there's a lot more interest in statutes and codes and less interest in cases. I would tell you more about the civil law system, but I really don't understand it much beyond what I've just told you. But before we talk more about the common law system that we have, I wanted you to understand that there are other systems in use around the world. They work for those worlds. I think ours works for our world. I suspect they each have their defects. I suspect each of them has a benefit that we wish we had, but it sort of falls into the grass is always greener on the other side. So before I talk more about the common law system, I'm switching back now to our system. Any guesses? Let's use chat. Any guesses as to which is that half state that does not use the U.S. system? Well, Gail Clam might have a little bit of insight. She's suggesting Louisiana. Someone else is suggesting Louisiana. Someone says Nebraska, Alaska, Hawaii, Utah. Interesting. DC. Well, the prize goes to Sharon, Marcella, Gail, and I can't tell who else. It is Alaska. No, I'm sorry, it is Louisiana. There are remnants of the civil law system in the United States, particularly in the Southwest, California, New Mexico, Arizona. The Spanish influence was very strong there. Even today, when you try to untangle some property issues, particularly property issues related to water, you frequently have to go back to a civil law system to figure it out. And you have to know Spanish. So there are still influences in the Southwest, but those are not civil law states. Louisiana is. Louisiana uses a combination of common law and civil law. I really don't understand how they work that. I do know that if you go to law school in Louisiana, after the first year, you have to choose whether or not you want to master the civil law system or the common law system. I could not practice, I don't think, in in Louisiana, because I just don't understand the civil law system. But in the United States, we still have influences from the civil law countries. And they came, of course, from who colonized them. France colonized Louisiana and parts of this area. Spain colonized the far west, and England, for the most part, but not exclusively, the East Coast. So let me give you a little description of how we came to have the common law system. And again, I'm going to do some screen sharing. So as I was just saying, we get it from England. I want you to think about medieval England. In fact, England pre-1066. Were there judges? Yeah, there were. Was there a legal system? Yeah, it was, but it was very local and it varied. So a lord who had an estate was the legislator, the governor, the judge, the executioner, and probably everything else on the manor. There were merchant fairs. There were people that came to market, right, to sell their goods. And so there developed someone who became the arbiter or the judge to decide any disputes among the merchants or between the merchants and the people buying the product. There were probably some kind of local courts around that took care of disputes within a certain area. Interesting, even though England was at one point part of the Roman Empire, there's a little of Roman law that persevered throughout into the modern era in England, but probably a little bit. So we mentioned the first day that in 1066, there was the Norman conquest of England. So it was an attempt to unify England. And if you're going to unify England, you ought to unify the courts. You ought to have a legal system throughout the whole country. And this gained its strength in 1154 under Henry II, who wanted to create a unified legal system and end all these local courts, these local judges, these local efforts at resolving local disputes. So imagine this. You're Henry II, and I know I'm dumbing this down and making it understandable to me and hopefully then to you. So bear with me that I'm making this simple, but I think this helps to understand. So here's Henry II, and he's got judges in England, and there's a dispute in some area, and he sends a judge out to settle that dispute. And there's a dispute in some other area, and he sends a different judge out, and so on. And they come back to London, and they discuss the cases that they had and the decisions they made. And eventually they try to get a commonality in their decisions. So it ought to be the same law that Judge 1 is using when he or she, I'm sure they were all he's, goes to this area, that Judge 2 uses in going to another area. So there was a discussion among the judges in an effort to develop the law. There's no parliament yet. There's no one passing statutes. The judges are creating the law based upon their wisdom. And this is today often known as judge-made law or case law or common law. We call it common law. One of the reasons I like to harp on this, and I will concede that I am harping on this, is because we frequently hear in the media from politicians generally that who are these unelected judges that go around making the law? They ought to just enforce the law as it's written. They ought not to be making the law. Well, if you're a conservative and you don't like a liberal judge, you say that about the liberal judge. And if you're a liberal and you have a conservative judge, you say that about the conservative judge. So both sides criticize it, but in effect, they are criticizing a process that has kept us in good stead since 1154. Magna Carta, John assigns the Magna Carta in 1214. It required that there be courts in order to resolve some disputes. So eventually, there developed a centralized legal system throughout England. This has a number of benefits. It unifies England. It curbed the power of the church, which had a lot of power over people in terms of making decisions. It provided some fines and forfeitures for the king's treasury. So what king's going to not like the idea of getting some money into the treasury from fines that are being imposed locally but sent back to London? And I think it provided some precedent for commerce. And here I'm going to pause and ask R.J. Robertson, who's a professor of contract law, commerce law, commercial law, if he wants to weigh in on how the common law system helped us develop commerce. RJ?
Yes, Suzanne. Part of the problem with commercial development is the reluctance of authorities to recognize new ways of doing business or new subjects of business. One of the advantages of the common law system is that if a new way of doing business comes along, the judge has the flexibility, because judges are allowed to create rules in the absence of legislation. The judge can decide, okay, here's a new type of sale, or a new type of mortgage, or a new type of property ownership, and I have to decide a dispute involving that. Common law judges have the authority to do that. Their job is to decide disputes. If there's no legislation, if there's no statute that provides a legal rule, where there's no binding precedent from a higher court, then the judge is expected to create a rule of law that will govern that case in similar cases. So common law systems are easier to go to and get relief if you're dealing with a novel issue of law or a new method of doing business. Civil law courts, judges don't have that authority. The judges are only expected to apply the laws from the code, that is, from the central legislative authority. If you have a new way of doing business and there's nothing in the existing legislative code to create a rule of law to answer the problem that the commercial people have, then the judge just refuses to take the case, and the dispute doesn't get resolved. And that provides a real lack of certainty for future transactions. So the flexibility of the common law is really essential to the evolution of more modern forms of commercial development. And I know there's been a ton of economic research that indicates that there's a high correlation between common law countries and economic innovation, particularly technological innovation. And, you know, as sort of this illustration, you might think about how many real modern technological breakthroughs have occurred because of businesses located in the United States, as opposed to, say, civil law countries like France and Germany. And I think a large part of that is because common law courts have this ability to change the legal rules as new circumstances develop. I've probably gone on too long, but that's sort of it.
Thanks, RJ. And it's interesting that in contracts made between businesses, and we're talking major international groups who choose where they want to have their cases heard, frequently they choose London or New York, and probably for the reasons RJ just described. So you should understand that common law or judge-made law was the primary source of law for hundreds of years before Parliament developed legislative powers, and it created law primarily governing contracts and property and criminal areas. Later, tort law, the very thing that we are dealing with in our car accident case. As the colonists come to the New World, now known as the US, the charters that they received telling them that they could come and claim land in the name of the king of fill in the blank, dictated the law that was often going to be followed. If there was not a charter, they relied upon what they were used to. So French settlements in what we now call Illinois, particularly along the Southwest, Randolph County, Monroe County, St. Clair County, those Cahokia, Prairie du Rocher, those early French settlements, they followed the customs of Paris. The customs of Paris. They were not common law. They were following a civil law system, the customs of Paris. And as I mentioned before, Louisiana certainly adopted the French system. We see the Spanish influence in the South. Eventually, though, all 13 colonies, the original 13, adopted the common law. Then the way in which they adopted the common law is called a reception statute, a statute receiving the common law. Now, you should know that in the early days of the colony, of the post-revolution, when the early founders of the country were trying to decide upon a legal system, they had to give some thought to which one to use. And there was a lot of suspicion of the British system because it had, as you know from some of Dickens' writings, it goes on forever and can be rather entangled. There was a general distrust of lawyers because many of them had been agents of the king. So the common law system becoming our system was not automatic. Jefferson, for example, argued in favor of a civil law system. He liked the French system, but he lost out in the debate. So the early colonies, now the early United States under the Articles of Confederation, adopted the common law. You will remember from your history that Illinois was part of the Northwest Territory. So in the colonial days, or Revolutionary era days, the Northwest Territory, now Illinois, Wisconsin, Indiana, Ohio, and Michigan, was the Northwest. That was the four-way area. And the colonists were starting to move out of the original 13 farther west, and we needed a legal system. Well, in those days, the governing body, we did not yet have a constitution. We had the Articles of Confederation. So the United States of America, the earliest form of government was the Articles of Confederation. And one of the things that passed was the Northwest Ordinance, providing for how you were going to move into the Illinois, Indiana area. And it said that as the people moved into this territory, they were to form a court to consist of 3 judges, any 2 of whom to form a court and share a common law jurisdiction. So that pretty well eliminated the French system in the French colonies in Illinois, and Illinois became a common law territory. Just a little bit of history, just because I get to indulge myself and share this. Keep in mind that in the Declaration of Independence, you see some of the criticisms that the founders made against England. They complained about King George, that he had obstructed the administration of justice. He had made judges dependent upon his will alone. So the judges could not get paid if they were not making the king happy. They deprived us, he says, in many cases, Jefferson says, in many cases, of the benefits of trial by jury. So in the Declaration of Independence, you see how important courts were to the founders, how much they did not want the influence of the king. And you see that obviously they had early courts. Now, I want to skip the next few slides for now and talk a little bit more about some common law concepts that have entered our national discussion. So here's a question I want to ask you. One of the common law doctrines is that you're not your brother's keeper. This is a common law doctrine that comes to us from England. You're not your brother's keeper or sister's keeper. So let me ask you this, and we're going to go to chat. And as I said earlier, I know a couple have come in late. On chat, you need to type in your answer and then hit enter or hit the return key. So think about this for a few seconds as I set up the question. Should there be a duty to save someone? And when I say that, I mean a legal duty, one you could enforce in court. So if Bobby and Dorsey are out bike riding and they see someone about to get injured on a bicycle, or they see someone who has been injured, do they have a duty to step in and either save them from getting injured and stop them from that accident, or attend to them if they've been injured? If Roland's sitting in his front yard and he sees a neighborhood dog that he knows is vicious running around and he sees someone walking, does he have an obligation to stop that dog from attacking that person? Or if the attacks happen, to attend to those injuries? Let me ask you, if you're hiking in one of the state parks around here and someone has fallen through one of those cracks and is however many feet down and needs help, should there be an obligation to save that person? So I'm going to ask you to weigh in on chat as to whether or not you think there should be a duty, a legal duty, not a moral duty, not an ethical duty, not a be kind to your neighbor duty, but a legal duty. Should there be a legal duty to save someone from injury, or if you see that they've been injured, to attend to them? So I'm using chat here because you may want to tell me why you think that ought to be a legal duty or not a legal duty. So just go ahead and weigh in on chat for a second here. Well, I'm seeing a lot of no's. I don't think I saw a yes, but I'm seeing a lot of people making a distinction between a legal duty and a moral duty. And I'm seeing yes, one for the common good. We have two yeses. Very good. A little discussion there, a little difference. Well, under the common law, there was no duty to put yourself at risk to help someone else. There was no obligation to help your brother. That is very well-established old common law. Well, as RJ mentioned before, the common law can grow, it can evolve, it can adjust to new situations. I think the bottom line is that even today, this is the law in the United States. There is no duty to help somebody, to save somebody. But here's the kicker. If you undertook to help them and you did so negligently, then you could be in trouble. Then you could be sued for negligence. So if you undertook to help somebody, even though you had no duty to do so, and you did it negligently, then you could be sued. Well, here's another feature of the common law. The legislature can come in. So in many states in the United States, including Illinois, the legislature has adopted Good Samaritan laws. So a Good Samaritan law basically says you didn't have a duty to act, but if you chose to act and it was an emergency situation, we're not going to hold you liable unless it was a reckless or intentional harm. So we've created these Good Samaritan laws. In Illinois, we have Good Samaritan laws for all kinds of groups, and I'm not going to go into detail on it, but it's interesting. You start to see how the common law and the legislature can work together. When the legislature does not like the direction of the common law, it can overrule the common law. Let me give you another example. Under the common law, there is no duty to clear your sidewalk when it rains or snows or sleets. No duty. So if you live, as I do, in an area where there's a sidewalk, and it snows or rains, or we have that messy season like we did last March, where we had snow on the ground for several days, no duty. Lots of folks in my neighborhood walk. I know they walk. I had no duty under the common law to go out there and clear my sidewalk. But those of you that live in Carbondale will tell me, aha, but I thought there was an ordinance, and there is. So the city of Carbondale has enacted an ordinance that says I have to clear my sidewalk. Again, here's an example where the legislature, knowing what the common law is, has said, yeah, we know what the common law is, but we think there's a better approach, and we're going to overrule the common law, which we can do by creating this ordinance. An ordinance is like a statute. And now you've got to comply with the statute. So the common law evolves, and sometimes it gets overturned by a legislature. Let me give you another example. Under the common law, if you had this car accident that we started on day one, and instead of being injured, you died, that was the end of it. Your estate, your family could not step in for you and bring the lawsuit. The lawsuit died when you died. But the legislature in this is an area where the courts have changed, and they have started to evolve. Maybe we want a little bit more room for people to bring lawsuits in the case with death. And then the legislature has stepped in and said, yes, we're going to create something called wrongful death. So in Illinois, there is a tort, T-O-R-T, called wrongful death. So if in this car accident, unfortunately, I'm sorry, but you died, your family could now step in your place and bring that lawsuit on your behalf. It limits who can bring it, and it limits the kind of damages you can get. That's up to the legislature to do, but the legislature limited the common law. Let me give you one more example, and this is from my childhood. Some of you know that my family owned a tavern. And I like to say I was born and raised in the tavern, but I wasn't born there, but I certainly was raised in a tavern. And I think the statute of limitations has ended. So I can even admit that at age 12, I was serving liquor at my mother's tavern because my mother told me I was going to serve liquor. Well, under the common law, so I learned early on about dram shop laws. And I'll tell you in a minute what a dram is. Under the common law, if the person who hit you in this accident had been drinking and he or she caused the accident because he or she was drunk, you could not have sued the person who provided the liquor. You could sue the person who was drunk, but not the person who provided the liquor. The theory was what caused the accident was not the providing of the liquor, but the drinking itself. So under the common law, we just cut off the causation at the earliest possible moment and said the person who caused this accident was drunk. He's the one liable, she's the one liable, not the person that provided the liquor. Well, again, in Illinois, we have a dram shop law. Dram, D-R-A-M. Now, indulge me, this has nothing to do with law, but I've always been curious as to what is a dram. And I can tell you, a dram is 1/8 of an ounce. And just in case you're not sure, I've got here a shot glass. It's a 2-jigger shot glass. See, this is a remnant of having parents who owned a tavern. This is the sort of thing you inherit. This is a 3-ounce shot glass. And it's hard for you to see, but if you can see the colored part, that is a little more than 1/8 of an ounce because I couldn't get it that small and have you see it. So that's a little more than 1/8 of an ounce. This is not liquor. This is water colored with grape jelly so you could see it. Just wanted you to see what a dram looks like. So a dram shop was a shop. We would call it today a tavern or bar or cocktail lounge that sold liquor by the dram. Well, again, under the common law, you could not sue the dram shop, the place that provided the liquor. You could only sue the person who hit you. Illinois, like I think every state in the union, said, no, we're going to extend that law a little bit. And now there is a statute that creates a cause of action against the person who provided the liquor, the dram shop. And again, because it's a statute, it limits who can bring a lawsuit and how much damages they can have. But again, it's a duty that did not exist under the common law, but the legislature has enacted it. I dwell on these a little bit to help you understand that even though we've developed the common law system since 1154, legislatures can come in and overturn and change the common law. So when you hear a legislator saying, who are these unelected judges who are making these laws, you might point out to that legislator that he or she could go to the state capitol and pass a statute to overturn that common law if he or she thinks the common law is bad. So common law has evolved. RJ told you a little bit about how it's evolved in the commercial sense. Let me go back to our car accident one more time. Let's say that the car accident was caused not by this person who ran the red light, but the car accident was caused because the tire was bad or the brakes were bad. Let's say the brakes were bad. So you had an accident because the brakes were bad. Well, why are the brakes bad? Well, the brakes are bad because they were manufactured in a poor way. Under the common law, you could not sue the brake manufacturer because under the common law, only the person that bought the product could bring the lawsuit. So under the common law, it was only the repair shop in town that bought the brake from the manufacturer. You bought the brake from the repair shop, but you did not buy it from the manufacturer. You could not have brought that lawsuit. Again, the common law courts said, no. Modern world, and this was in 1917, they said, hey, we've got to adjust to the modern world. People don't buy directly from the manufacturer anymore. There's this chain of commerce from the manufacturer to the shop to the to the ultimate user. We're going to let people sue. So again, I know I'm harping on this, but I want you to understand how the common law system operates. It does evolve, it does change to adjust to the world that we all live in. And when it fails to, the legislature can step in. Now, I'm going to take a break in just a couple minutes, but I'm going to leave you with a question for discussion. The question I'm going to leave you for discussion is, now that we know the legislature can intervene and change the common law, in a given case, is it better for the court to do it, or is it better for the legislature to do it? And I want you to think about this. You're having a party. It's the holidays, or it's July 4 and you're having a backyard barbecue. And you're serving liquor. You're not a liquor establishment. You're not a dram shop. You're you, and you have guests over, and you're having a party, and you're serving liquor. And somebody indulges in the liquor and goes out and has an injury to himself or to others. So maybe the person gets drunk enough that he has a car accident with a one car hit the tree accident and is injured or even killed. Maybe it's a accident where he or she injures someone else. We do not in Illinois right now have what's called social host liability. We do not say that you who were the host are liable for the injury caused by the person who drank while he or she was in your home or your backyard and then proceeded to injure someone else. Should we? And if we should, is it better for the court to make that choice, or is it better for the legislature to make that choice? So I'm going to take a 5-minute break. And as I take that 5-minute break, I want you to think about that. Who's in a better position? Who could better identify all the people that might be involved in this decision? Who could think through all the issues and come up with a plan, either a court decision that gives guidance to future courts or a legislature that creates a statute? So let's assume that we want to have social host liability. Maybe you don't, but let's assume we do. And should it be the court? Should it be the legislature? I'm going to take a 5-minute break. I'm coming back at 10:36, and we're going to find out the answer to this question. Thank you. Okay, I'm back and I'm looking at the responses. What if liquor is served to an underage person, the server could be liable, right? Someone prefers the courts decide, someone else the courts, another person the courts, but the legislature could change it to courts. Okay, well, I'm going to come back and answer some of the other questions, but let me explore this a little bit with you. All right, so you're in your backyard, you're having guests. Here's a question. What if you provide the liquor? Or what if you don't provide any liquor, but someone else brings the liquor? Or maybe you even said, this is a no liquor party. Do not bring liquor, and someone does. And over there in the corner, everybody knows, go over there in the corner because that's where the good stuff is. And someone's got the cooler with the liquor. Are you liable in that case? Or are you liable if it's a minor that consumes the liquor, but not if it's an adult that consumes the liquor? Who would be interested in a case like this? Well, the insurance companies will, because the insurance company is insuring your home. And probably if we're going to have social host liability, there's going to be provisions for insuring you if you serve liquor in your home. So they're going to be interested. The car insurance companies are going to be interested because if there's somebody else involved in this lawsuit besides the driver, they're going to want to know who provided that liquor. Homeowners, realty companies are probably going to be interested because they're going to want to know when they sell homes, this is a positive for selling a home or a negative for selling a home. Gee, there might be liability. Should you have training? So liquor store or dram shops, what we know today as bars, cocktail lounges, taverns, pubs, they have to have training, right? The people that serve liquor get trained to know when to tell somebody to stop. Or is every homeowner who's going to have a party with liquor going to have to undergo training? Does it make a difference what the law is in the city or the county with regard to liquor for public establishments, for restaurants, taverns, and so on? Does that make a difference or does it not? What if you have teenagers and your teenager wants to have a party and you have said more ways than one, no liquor, no liquor, no liquor. And the kids come and they bring liquor and then somebody gets intoxicated and has an accident. Are you liable? Are you liable because you weren't there? Are you liable if you are there? What if you say no liquor, but the kids know you have a liquor cabinet, you had it locked and they break in, they get the liquor anyway? You see all these questions? These would all be questions. Now, if the court had this matter, a court could only decide between the two parties in front of the court and the issues that brings up. So if in this case that we've had this car accident, you were injured at that intersection of 13 and Glenview by the driver who ran the red light and was intoxicated. And now you're going to sue the homeowner where that driver came from, where there was liquor. The only question that the court can decide are issues with regard to that particular accident and that driver and that home situation where you were serving the liquor. Can't decide about minors if this was an adult. Can't decide about adults if this is a minor driver, a driver who's underage but old enough to drive. The court can only decide between those two parties and that particular case. It can't consider all the other issues that I just outlined. But a legislature could. A legislature could convene a hearing and could have everybody come and talk. Insurance companies, come on in and tell us what you think are the issues. Cities and counties that have your own liquor control laws, come on in and tell us how you think you're going to be affected. Everybody who's interested could come. So this, I think, is a case where we might think that the legislature, if it chose to, would be in a better position to consider all these issues than the court, which can only consider one issue at a time. However, the alternative side of that is, well, what if we really need social host liability? And what if the Illinois legislature just plain won't act, just won't act? Well, then maybe the court does have to make a decision and move the law forward rather than do nothing. And that's the situation we're in right now. The Illinois Supreme Court has faced two major cases in the last 40 years on social host liability. Back in 80 something or another, it said, no, go to the legislature, and the legislature has not acted. And more recently, there was another case that created a little bit of a window opening to a social host liability in Illinois, but we still don't have it. Now, somebody asked me how many other states do. Many states have social host liability, and they are continually trying to decide cases one by one. What about a minor who is invited to the party and the parents are there and the minor drinks and then goes out and has an accident? What about a case where it was an adult who did the drinking? What about a case where you said no liquor in my party and somebody brought the liquor anyway? All those facts are getting resolved one by one in various states, and sometimes by the legislature changing the law and sometimes by the court. So I think I've taken enough time on that issue, but I just want you to see, it's sort of a political science question, isn't it? Who's in the better position to make some of these decisions? Is it the court? Is it the legislature? And when, excuse me, when the legislature won't act, should the court? And probably because I'm a product of the legal system and the common law legal system, I get irritated when I hear legislators complain about courts, and I know it's because the legislature failed to act. If they had the courage to make decisions, then sometimes the courts would not have to. Now, I'm not telling you that I agree with every court decision ever. I have a long list of cases I've lost. So there are plenty of times when I've disagreed, but that's the system. All right, one more topic that I want to take up this morning, and that is yet another common law concept. And that is the concept of sovereign immunity. So back in England, everything goes back to England to the Middle Ages. Back in England, the law was the king can do no wrong. Can't sue the king or queen. A better view of it is that the public treasury should not be used for private good, but only for public good. So if someone got harmed, it ought not to be the state or the nation that compensates them, but the one who harmed them. And if that happens to be the king, sorry about that, the money's better used for public good than for private good. But basically the concept was the king can do no wrong. Well, in America, that concept comes to us through the common law system. And in Illinois, in 1970, when the Illinois Constitution was rewritten, the Illinois in its Constitution abolished sovereign immunity. So if you read the Illinois Constitution, it says no sovereign immunity, which means, going back to our car accident case, the accident happened not at 13 in Glenview, and not because somebody ran the red light, but at some other intersection that was poorly designed. If you remember the day one, we talked about who might be the defendant, and we identified the driver, obviously, as the defendant. But I said there could be other defendants. And I said that if you had a situation where there were a very poorly designed intersection so that people could not see, did not know which way they were supposed to go, and that created the accident. Or you had stop signs, but they were down and the state did not attend to them, assuming this is a state highway, and therefore you did not see that you were to stop, and that's why you hit someone. Or as I see all the time, the state is not trimming trees and weeds, and the signage was blocked, and you did not see the stop sign and did not stop. In other words, the state was at fault. Could you sue the state? Well, under the Illinois Constitution, yes, you could. But the Illinois Constitution went on to say, while we abolish sovereign immunity, we will leave it to the legislature to decide whether or not to enact it. And lo and behold, the legislature did. So today in Illinois, you cannot sue the state of Illinois in state court if the state fails in its duties, if the state is negligent, or if the state enters into a contract with you and doesn't pay. Well, that sounds pretty terrible, doesn't it? Let's say that you are a merchant in Carbondale, Illinois, and you sell products to the Southern Illinois University, and Southern Illinois University does not pay the bill, and you would like to get paid. You cannot go over to Jackson County, Murfreesboro Courthouse and sue the state of Illinois for that contract. Or if you got injured in that car accident there's some rural state highways. Once in a while, I find myself along the line of Perry County and Randolph County, and there's some little used state highways with stop signs. And let's say the signs are down and there was plenty of time for the state to know that and fix it, and the state did not, and somebody gets injured at one of those intersections, and it's the state's fault. You could not go over to the county courthouse and sue the state. But the legislature, again, you see the relationship between the common law and the legislature. The legislature has stepped in and created something called the Court of Claims. I'm probably one of the few people that you know in Southern Illinois that actually understands the Court of Claims, because for 2 years, I defended the state of Illinois in the Court of Claims. And the first thing you need to know about the Court of Claims is it is not a court. I know it sounds like a court. It's not a court. It's an advisory body to the state General Assembly, to the legislature. But here's how it works. The state has created a court, okay? It sort of looks like a court. It has judges. It has rules of evidence. It has complaints. When I finish, you'll understand why I don't call it a court. So if you had this car accident at one of those intersections that was poorly marked, poorly designed, that caused your injury, you would have to sue the state of Illinois in the Illinois Court of Claims. Or if you run a restaurant in town and you provided pizza to the Southern Illinois University for some student event and the university failed to pay the bill, you would sue the state of Illinois in the Court of Claims. You would file a complaint there. And the Attorney General's office, which is the attorney for the state, would defend. And there would be a hearing where evidence would be presented. The rules of evidence are relaxed somewhat, but basically there would be a hearing where evidence would be presented. And a decision would be reached by a commissioner. A commissioner is someone appointed by the judges of the court to hear the evidence. And that recommendation would then go to the court, which consists of 7 people appointed by the governor to the Court of Claims, and they would make a final decision. And they would decide, yes, Peggy Eyes is entitled to $9,500 for the pizza it provided and the state failed to pay. Or yes, you are entitled to $40,000 for your injuries due to this accident. Maybe $100,000. Now, what happens? Well, the state has to pass a bill through the General Assembly, has to pass an appropriation bill in order to give you the money. That's why I say it's not really a court, it's an advisory body to the legislature. So basically what the court says to the legislature is, legislature, you appointed us to hold a hearing to determine whether or not this person was owed money. And we've determined that, yes, they are. And now we're coming back to you, legislature, and we're saying to you, please pay the bill, appropriate the money and pay the bill. That's the Illinois Court of Claims. There is at the federal level a similar kind of thing called the Federal Torts Act, which allows you to sue the federal government for claims against the federal government. It operates differently than the state system, and I can't tell you how it operates other than there is such a system. So you're not totally out of luck if the king or the state is the one negligent. But we have inherited this concept from England. The king can do no wrong. The doctrine of sovereign immunity, you cannot sue the sovereign. And again, the legislature, and in this case, the Illinois Constitution plus the legislature has created a vehicle by which you can do so. I will have to point out that it has said, the courts have said, that there are certain duties of state employees that you can sue in state court. So when a state driver, a person driving one of those SIU cars, has an accident, you can sue that driver in state court as you would any other driver, because the concept is that driver owes the same duty to you as does every other driver. A state doctor, a doctor working at a mental hospital in Illinois or a prison in Illinois who malpractices, can be sued in state court because the doctrine is that that person, that doctor, owes the same duty as any other doctor and can be sued. So this is a long discussion about common law coming to us from England, received through the colonist to the colonies, or to the states as they became states, adopted nationwide, except to some extent in the Southwest on certain matters, mainly property, and not adopted in Louisiana totally, only partially. As we've pointed out, it evolves. It is made by the courts. It creates guidance because the law is supposed to be presidential, P-R-E-C-E-D-E-N-T-I-A-L. That is, we create precedent that guides your behavior for the future. So you have some guidance as to how the courts would make decisions. So you can plan your business affairs, your personal affairs, but it also evolves with time to adjust. And finally, it can be changed by the legislature. Again, my reason for spending some time on this is to just deal with issues that we often hear in the news. I am pretty well finished with what I wanted to do today, because if I start another topic, I'm going to go too long. So let me just pause and devote a few minutes to questions, whether it be questions of what I talked about today or questions of something that's in the news. Anything you've heard about in the news, you wondered why could that be? Well, while you're taking a few seconds to see if there's any other questions anybody wants to ask, I will tell you what we're going to do next week. So going back to our theme, looking behind the veil of a civil lawsuit, next week we're going to talk about the people that are necessary to have a civil lawsuit. Who are the lawyers and who are the judges, and how do we get judges? And in that regard, I am going to compare it to the civil law system that exists in primarily continental Europe, but also Japan, interestingly enough. But I also want to talk a little bit about some of the little known people that you may not think about: the court reporter, the interpreters. I'm going to leave you with this question to think about for next week. Who do you think is in control of the courthouse? And when I say in control, let's go to the ultimate question: who gets to close it down in case of bad weather? Who do you think is in control of the courthouse? So think about that question. We'll start there next week. But that's my plan for next week. And my plan for the last week is to show you some alternatives to the civil trial system. So what are some things that are going on in the United States, but also primarily Canada, that are some alternatives? Any questions that anybody has? Well, then we're going to finish early today. Thank you very much, and I will see you next week, and we will explore who are the people behind a civil jury, a civil trial. Thank you. See you next week.
Thank you, Suzanne.
Thanks, Suzanne.
Thanks, RJ, for helping out.
Thank you.